Hi, I'm Jim Beatty, Associate Dean and Professor of Constitutional Law at Capitol. Today, 227 years ago, 42 delegates had a quill pen handed to them and were asked to sign what we now call the United States Constitution. Interestingly, only 39 signed. Those that didn't sign had three major concerns. First, this new national government that had been created, they were concerned that it would effectively eviscerate state autonomy and traditional state powers. They were also concerned that the powers that had been delegated to this new national government were ambiguous and capacious. For example, the national government got taxing power, spending power, the Commerce Clause power, and last but not least, the Necessary and Proper Clause. Those that didn't sign were concerned that the national government could claim to do anything as long as they said it was necessary. And lastly, and most importantly, it didn't have a Bill of Rights. All state constitutions up until this point had a Bill of Rights protecting the fundamental liberty interests of their citizens. Those that did sign conceded that this was an imperfect document. It was a compromise, but it was the best compromise that we could achieve at the time. And more importantly, they claimed it was absolutely necessary and proper to address the problems facing our nation at that time. We were in a severe depression. We had tremendous military debt from the Revolutionary War. There were threats from without because England and France were up to their old shenanigans again, and we had threats from within because the Articles of Confederation essentially left one state against another state and is essentially a mini Europe on our shores. New York and Rhode Island acted like England and France when it came to their economies and their trade wars. Secondly, they said that the powers given to this national government were not ambiguous and capacious, but instead they had been specifically limited by enumeration, and anything that wasn't enumerated was thereby reserved to the states or to citizens respectively. And lastly, they didn't feel that a Bill of Rights was necessary. One, because, as I said, the rights were limited by enumeration, and two, any laundry list of rights could arguably limit those that were on the list and thereby disparage them, or lastly, inadvertently leave a right off the list and thereby deny them. Well, you've briefly heard the arguments on both sides of this issue. Today, I ask you to imagine that you're back in that room in 1787 and you are the 43rd delegate to the Constitutional Convention, and the quill pen has been handed to you. And the question is, will you sign or won't you sign? I look forward to your decision.
We, the people of the United States,
in order to form a more perfect union,
establish justice, ensure domestic tranquility,
provide for the common defense,
promote the general welfare,
and secure the blessings of liberty to ourselves and our posterity.
Do ordain and establish this Constitution for the United States of America.
Well, Capitol University Law School, you've heard the preamble, so you can remember what it is that the framers were trying to do in the Constitution. You've heard the arguments for and against ratification, and now the choice is yours. Will you sign or won't you sign? Come to the back lobby and decide.